Hello, everyone. My name is Charlotte Mitchell. I'm a PhD candidate at the University of Alberta, and this paper presents research in progress as part of my thesis. There is a long-standing history of women participating in the sport of ski jumping dating back as early as 1863 in Norway, despite systemic gender discrimination and exclusion women faced in the sport. The discrimination and exclusion of women from ski jumping was often rooted in gendered ideals of masculinity and femininity and protectionist attitudes towards women and their bodies. Men's ski jumping has been an Olympic sport since the first Olympic Winter Games in 1924. Yet, a women's event was only recently added to the Olympics 90 years later in 2014, following a significant campaign by women ski jumpers in the early 2000s and a human rights lawsuit in 2008, citing a violation of the Canadian Charter of Rights and Freedoms. The Charter protects fundamental freedoms such as equality rights, among others. However, legal historiography identifies shortcomings of the Charter for cases of systemic discrimination. Legal scholars Joshin and Watson Hamilton argue that Section 15 of the Charter that protects equality rights has ultimately resulted in the lack of success for equality-seeking individuals and groups before the Supreme Court, and they highlight the need of Section 15 to better address issues of substantive equality. Young examines how the Charter failed to challenge the power of the IOC, or the International Olympic Committee, and the treatment of women in the case of women ski jumpers. Decades before legal efforts for the inclusion of women ski jumping in the Olympics, women ski jumpers fought to fly and advocated for their own inclusion in national and international ski jumping in various ways. I argue that while the lawsuit was unsuccessful in using the law to make change for the 2010 Vancouver Olympics and obtain substantive equality, the lawsuit and advocacy campaign conducted by women ski jumpers and allies between 2002 and 2014 brought to light existing inequalities in sport and the Olympics, challenged perceptions of the IOC and the effectiveness of Canadian law, and ultimately led to the inclusion of a women's ski jumping event in the 2014 Olympic Winter Games. This paper will look at early efforts towards equality in women's ski jumping between 1994 and 2004, formalized advocacy for Olympic inclusion between 2006 and 2008, the lawsuit between 2008 and 2009, and the impact and aftermath of the case. First, let's look at early efforts towards equality for women in ski jumping. Women's official participation in ski jumping was a rapidly expanding in the 1990s. In 1994, Eva Ganster was the first woman to forejump for ski jumping in the Lillehammer Olympic Winter Games. In the following year, a women's demonstration event was held alongside the 1995 Nordic World Championships held in Thunder Bay, Ontario, where 42 women athletes from three nations competed. In 1996, the International Ski Federation, or FIS, established the first women's ski jumping working group. In anticipation of the 2002 Olympic Winter Games in Salt Lake City, Utah, United States ski jumping clubs and parents drafted a 7 years goal document between 1995 and 2002 with the aim of increasing participation of women in ski jumping and crafting a pathway for that inclusion in the 2002 Olympics. The document outlined the importance of increasing participation for women and girls in the sport across both ski jumping and Nordic combined at the local, national, and international levels, obtaining more funding, increasing opportunities for recognition of women and girls through awards, providing equal travel and training opportunities for women and girls, and recruiting and showcasing women ski jumpers. During this period, FIS noted that, quote, the danger involved in ski jumping has been drastically reduced within the last decade, and the idea must be to put more focus on the possibility to involve women more in the sport of ski jumping, and to begin to organize more official competitions for women. However, these competitions were often held on much smaller hills at a much smaller scale than men's ski jumping competitions during this time. Initial efforts for the inclusion of women's ski jumping in the 2002 Olympics were ultimately unsuccessful. However, momentum was increasing between the 1990s and early 2000s and in 2002, the 44th FIS Congress in Miami approved a Ladies Continental Cup circuit and Junior World Championships for women ski jumpers, and the first FIS Ladies Continental Cup, which was held in Park City, Utah, with 24 competitors from 7 nations. Women's participation in ski jumping continued to grow between 2006 and 2008. Led by individual efforts of athletes and grassroots ski jumping organizations, women support for women's ski jumping rose to the international level as well, despite a lack of support from the IOC and its executive branch. At this time, formal advocacy efforts for the inclusion of a women's ski jumping event in the Vancouver 2010 Olympic Winter Games began to emerge in the public. The president of Women's Ski Jumping USA, Dee Corradini, also the former mayor of Salt Lake City, Utah, started a petition in 2006 to try and get women included in the Olympics. The formal petition stated that, quote, "We, the undersigned women Nordic jumpers, do hereby request to be treated fairly and equally without discrimination or bias. As such, we ask the FIS and the International Olympic Committee to support women Nordic ski jumpers and to be included in Nordic ski jumping competitions at the highest level, including the FIS-sanctioned World Championships and the Olympic Winter Games." The petition was signed by 51 women ski jumpers from 9 countries. In Canada, organizations advocated for change at the national level. Board member of the Vancouver Organizing Committee for the 2010 Olympic and Paralympic Winter Games, or VANOC, and IOC member Becky Scott raised the issue of wanting to support ladies ski jumping for the 2010 program to the VANOC board in 2006. The Canadian Olympic Committee, or COC, also voiced their support. COC President Michael Chambers made a formal request to the IOC for women's ski jumping to be added to the Olympic program in 2010. However, at an IOC executive board meeting in 2006, the IOC voted to not include a women's ski jumping event on the Olympic program for the 2010 Olympic Winter Games. Women ski jumpers and Canadian National Sport Organizations, or NSOs, responded to the decision by the IOC in a number of ways. Ski Jumping Canada wrote to VANOC in January 2007, stating that the IOC violated principles of gender equity enshrined within Canadian legislation as well as within their own IOC charter, and requested that the VANOC board, quote, "ensure the strongest message possible is sent to the IOC, urging that the decision be reversed and to ensure a time slot remains open on the Olympic ski jumping schedule so that if the IOC decision is reversed, there will be a half day left open for women to compete." Jan Willis, the mother of Canadian ski jumper Katie Willis, filed a complaint to the Canadian Human Rights Council on February 2, 2007. In the complaint, Willis alleged that the Canadian Department of Heritage failure to intervene with the IOC's decision to use public funds to host men's ski jumping and not women's condoned these discriminatory actions. The complaint was later settled through mediation, where parents of Canadian women ski jumpers, Ski Jumping Canada, the COC, VANOC, ministers of parliament from the Canadian federal government, and Sport Canada met and determined next steps, which included letter writing to the IOC, a meeting between the Secretary of State responsible for Foreign Affairs, International Trade, and Sport, and Jack Rogue, the president of the IOC, identification of key individuals within the IOC that may be able to help advocate on behalf of women jumpers, and the agreement that all parties limit media responses. The complaint brought federal government officials and key members of national sport organizations together with an aligned strategy for how to advocate for the inclusion of a women's ski jumping event in 2010. Reflecting back on the complaint and the settlement, Jan Willis described how slowly the government moved on this issue and how they were, quote, "given the runaround, and the complaint didn't really amount to anything. It was disappointing." In 2008, letters were written from the federal, provincial, and municipal governments to VANOC and the IOC that reiterated the support for the inclusion of women's ski jumping in the Olympics. At the municipal levels, the City of Vancouver and the District of Squamish, BC, passed motions calling for the inclusion of women's ski jumping in the 2010 Olympics. However, the IOC reaffirmed their decision to exclude women's ski jumping from the 2010 Olympics during an IOC Executive Board meeting in April 2008. In response, women ski jumpers filed a lawsuit through the British Columbia Supreme Courts on May 21, 2008, against VANOC, arguing that the exclusion of a women's ski jumping event from the Olympics was discriminatory and violated Section 15 of the Canadian Charter of Rights and Freedoms. The plaintiffs included ski jumpers from Canada, Norway, Germany, Slovenia, and the United States. The oldest plaintiff was 32, and I was the youngest plaintiff at just 14 years old during this time. The lawsuit played out in different ways for organizations, clubs, and plaintiffs involved in the case between 2008 and 2009. For VANOC executives and board members, the women's ski jumping court case was a persistent issue that required the attention of the CEO, finance committee, and legal counsel as the case proceeded. When reviewing VANOC board meeting minutes from March 2009, I found that when VANOC's chief legal officer provided litigation updates to the board, emphasis was placed on the importance of public perceptions and the need for a, quote, carefully managed communication strategy. The board also discussed if VANOC would pursue claiming costs against plaintiffs if the judge was to side in favor of VANOC. However, some board members expressed that this may harm VANOC's reputation further. The IOC maintained that the exclusion of women's ski jumping was based solely on technical merit, despite contradictions to this claim. While VANOC was under growing pressure from the Canadian government officials and the public to advocate for the inclusion of women's ski jumping to the IOC, they ultimately did not dispute these claims. Dick Pound, member of the Canadian Olympic Committee and IOC, felt that the legal case was, quote, silly, and all it would do was piss people off. Local ski jumping clubs and NSOs supported the inclusion of women's ski jumping in the Olympics, but did not necessarily support the legal case brought against VANOC. For example, Brent Morris, chair of Ski Jumping Canada at the time, felt that it was not the right path. One of my participants also shared how she felt ostracized from the local Calgary ski jumping club during this time because of her participation in the lawsuit. Zoya Lynch, a former Canadian ski jumper, shared that it was a challenge for her to be a plaintiff in the lawsuit while also training full-time as an athlete. Within the Canadian ski jumping community, Lynch described how it was hard on coaches who didn't want to, quote, rock the boat. Katie Willis described the reaction to the lawsuit as mixed, sharing that, quote, there were some people that were very opposed to it. They wanted us to keep quiet, but then ultimately at the same time, she thought they were gaining a lot more attention from support from people in the news, other people in the sport or relatives, family and friends, and ultimately that it was nice to see that support too, despite some of the pushback. On July 10th, 2009, the BC Supreme Court Judge Justice Fenlon ruled that the exclusion of a women's ski jumping event from the 2010 Olympics was discriminatory. However, it was determined that VANOC did not have the power to add or remove events, and the IOC did not need to abide by the Canadian Charter of Rights and Freedoms. As such, no events for women in ski jumping took place during the 2010 Olympic Winter Games in Vancouver. Ultimately, the women's ski jumping lawsuit was unable to obtain substantive equality for women ski jumpers who were being discriminated against by the IOC through their exclusion from the Olympic Winter Games. However, it did result for change for women in sport. A women's ski jumping event was later added to the Olympic program for the 2014 Olympic Winter Games in Sochi, Russia. Plaintiffs who were athletes in the women's ski jumping lawsuit felt the impact of the lawsuit was twofold. The lawsuit was seen as contributing to the inclusion of a women's ski jumping event that was later added in 2014. However, this decision was too late for many of the more senior women athletes who entered adulthood during the lawsuit and ultimately retired from the sport in 2010. Women ski jumpers who were interviewed shared that while they were not able to personally benefit from the aftermath of the case and the inclusion of women ski jumping in the Olympics, they saw the impact of the case in the sport of ski jumping and beyond. For example, one of my participants shared how she felt the women's ski jumping lawsuit contributed in some way to the inclusion of women's boxing in 2012 and women's canoe kayak in the 2020 Summer Olympics. Thank you.